And we'll have no displays of support or opposition for those testifying here today. And we will go ahead and start with having senators introduce themselves, starting on my right with Senator Holler.
Thank you, Mr. Chair. Good afternoon, Senator Steve Haller in District 33, which is Adams, Kearney, and Phelps County.
John Lowe, District 37, Kearney, Gibbon, and Shelton.
Ray Aguilar, District 35, Grand Island.
Rita Sanders, District 45, which is the Bellevue Offutt community.
Jane Raybold, City of Lincoln, Legislative District 28, right in the heart of the city.
And I'm sure Senator Conroy will be back in a few minutes here. So with that, we will go ahead and I will hand the gavel off to the Vice Chair. I'll do my introduction.
Good afternoon.
Good afternoon. Well, today gets to be the last time I sit in this chair, so let's try and see if we can get it right. Vice Chair Sanders and members of the Government, Military, and Veterans Affairs Committee, my name is Senator Tom Brewer. That's Tombrewer. I'm here to introduce LR 362. After attending a briefing on artificial intelligence at the University of Nebraska Lincoln and February 24th this past year, I heard several folks on this new topic. We heard from some of the things that could be pretty scary if they come true. Now, a lot of the information was pretty conceptual, but today's concepts can be tomorrow's problems. And so I introduced LR 362 so that we could get a lot smarter on this issue. This afternoon, I think we'll have a number of folks that have extensive knowledge in technology and how it works and how it can be used. For those of you who still are returning back to the legislature, I hope that this will kind of help set the foundation for looking at some future bills specific to AI and elections. So with that, I will wrap up and take any questions.
Are there any questions?
Right, again, Senator Cavanaugh will follow me, and we're kind of looking at two sides of things. We're looking at the actual election part of it and how it could be affected. And we're also looking at the campaign part of it and how that can be affected. So as you're listening and thinking through, just keep those two different things in mind and how it could negatively affect either of those. So I will wrap up and turn things over to Senator Cavanaugh.
Thank you, Senator Brewer. Good afternoon, Senator Cavanaugh.
Good afternoon. Good afternoon, Chairman Brewer. And you could have just easily said age before beauty is the determination of the order.
I could have.
Good afternoon, Chairman Brewer and members of the Government, Military, and Veterans Affairs Committee. My name is Senator John Cavanaugh, John-Cavanaughh, and I represent the 9th Legislative District in Midtown Omaha. Thank you to Senator Brewer for holding this combined hearing on LR 362 and LR 412 concerning the potential dangers of artificial intelligence in elections and campaigns. Last session, I introduced LB 1203, which would regulate the use of deceptive media created using artificial intelligence in political campaigns. At that hearing for that bill, I heard constructive feedback from opponents and members of the committee about the difficulty of balancing the concerns of emerging technology while still protecting our First Amendment rights. When I brought LB 1203, I didn't know much about artificial intelligence, but knew enough to be concerned about the potential for deep fakes and impersonation of public figures to mislead voters before an election. I've learned more about AI in the last year, although I still don't claim to be an expert. There are uses of AI ranging from the frivolous, humorous parody songs or fake AI covers of real music, to productive, basic photo editing. Last week, I even asked ChatGPT to provide a description of my legislative speaking style. I won't bore you with the details, and you can look it up judge for yourself to see whether it's accurate. But even those benign uses have the potential to be abused for the purpose of misinformation. A few weeks ago, a candidate for president reposted an AI-generated image of a world-famous pop singer falsely purporting to express her support for his candidacy. In January, the Nebraska Examiner reported on a project that recreated the voices of members of the Nebraska Legislature using artificial intelligence. The results were unsettling. It's not hard to see the potential danger here. As technology improves and becomes more widely available, the use of artificial intelligence to spread misinformation becomes a more ever-present threat. My hope is that this hearing gives us some guidance moving forward to address AI in the next legislative session. There won't be a simple solution, as technology is ever-changing and we're struggling to keep up right now. But together with the stakeholders in this room and throughout Nebraska, I believe we can reach some common ground. And thanks again to Senator Brewer and the Government Committee, and I'd be happy to answer any questions.
All right. Can I start with the first question?
Sure, committee.
You talked about chat. You said
GPT.
GPT. Since you're much younger, can you enlighten me on this?
Yeah. Well, ChatGPT is one of the, I think, largest and most mainstream used AI programs. There's a free version and then there's a pay for version. And as far as I know, the only difference is the pay for version allows you to have unlimited number of requests, and the free version limits you to a certain number of requests a day. But you can submit any kind of question. So in the example I used, I just said something to the effect of, "Can you please describe the speaking style of Nebraska State Senator John Cavanaugh?" And it gave me about 2 paragraphs talking about how I speak on the floor of the legislature. And so you could probably do it for anyone who's been in the legislature for a number of years. You have to have enough material for it to scrape to come up with. But it gave me a 2-paragraph description that I was flattered by, so I think it's accurate. But but who knows if others would feel the same. But you can also ask it to generate images. You can give it a prompt and describe something, and it'll create more cartoonish images than realistic, but the technology is advancing. So you can, give it a request to, ask for a picture of clowns golfing or something like that. And it'll give you a group of clowns out on the links in sort of, whatever style you ask it to.
So back to your request for you to be able to hear your speaking style. And so somewhere it is able to go into some giant cloud that has all this data and grab it real quick, stuff it together, and give it to you.
Right.
Explain to me how all that works.
Well, that's how it works is well beyond me, but my understanding is that it takes the publicly available information, so it probably goes in and goes to the transcripts of the Nebraska Legislature, and anytime I'm talking, and then creates an aggregate of all the times that I'm credited as talking, which will show up like here. This will be in the transcript listed. Senator John Cavanaugh says, this. It'll take that information, put it all together, and then create a descriptor of that. And so then you can take that information after it's created kind of a profile for me and ask it to write a speech that it thinks I would give about a certain subject. And the concern here is really you could do that sort of thing to create a speech in your style. And then you can use the other technology, which that one I'm less familiar with, have never used, but that the examiner used to create a audio representation of making it sound like I said something I never said. And so I think that's the concern in terms of AI being used, is where it can be easily and very cheaply, cost effectively used to generate believable audio or video representations of elected officials or candidates speaking words they never spoke. And voters could be basically hoodwinked by that. And that's, I think, the concern we need to address. while still respecting people's opportunity to express themselves freely.
What I'll probably do on the close is we'll just combine the close, let you do the close, mostly because I think a lot of what we're going to talk about forming new legislation and all, I'd like to have your lawyer mind to kind of say, there's a point we're going to cross over and take away certain rights we probably shouldn't. So we'll see what comes out of the discussion today. We've added Spike as the final speaker today. He too, like you, is a brilliant attorney. So between the two of you, we should be able to sort it out.
Brilliant minds.
Okay, questions? Yes, go ahead, Ray.
Senator Cavanaugh, you said that this could generate information about John Cavanaugh, if you will, and it's accurate information. Why wouldn't that be considered an invasion of privacy?
Well, the information, and there may, I think there are opportunities for this technology to stray into invasions of privacy, but the information, my understanding, is publicly available information that it's scraping. I do think there are legitimate complaints about how artificial intelligence is used to build some of these models off of non-publicly available, and I think creators, artists, are coming up against that, where they're litigating their intellectual property being used by these large language models, is what they're called, but like where they compile all of the artistic works of, say, Stephen King, an author, and say, now write me a book in Stephen King style. That is essentially violating Stephen King's intellectual property. While I do agree that that's a potential problem, it's not the problem we're attempting to address here. So I agree with you that that's a concern, that there are other potential concerns. This, for my mind, this issue is big enough for me, and I'm trying to wrap my mind around. So I'm not striving to address others at the moment.
Thank you.
All right, additional questions? Senator Lowe.
Thank you, Chairman. Thank you, John. Or Senator Cavanaugh. Have you thought about using AI to write this bill in your style?
Yeah. Well, the great thing about our bills are that everybody has the same style because we use uniform bill drafting here. No, I hadn't thought about doing that. I did think about using it to write my opening remarks, but I think there is some ethical questions about that, about using AI and passing that off as something you actually did. I think we're getting to a place where people are being more comfortable with that. As AI improves, there's a classic story about a lawyer using it actually for their briefs, and it made up cases. So it's not smart enough to know to distinguish. So there's places where you can get caught up just by being the person who uses it. I'm more concerned about the person, the hearer. So if I came in here and passed off, if I gave my opening remarks and they were written by AI and I didn't disclose that to you, that's kind of the space that I'm concerned about, is that you would think I'm more eloquent than I am as a result of using it.
And isn't AI only as good as the programs that were written to control it?
I think so. And the user's prompts and how they use it. But yeah, but the concern is that it's going to get so good that less talented individuals could use it more effectively and therefore more effectively deceive voters, which is kind of what my investigation is about. And the question I would like us to get to is, what, if anything, can or should we do about that as a government? I proposed disclosure this year on my bill 1203, and we ran into some problems, just how to actually make that work effectively, who's responsible for that disclosure, who's responsible to make the determination about what's fake and what's not fake. And so there are a lot of questions that need to be resolved before we can take any kind of action, but there is a question about what action should be taken to begin with. So,
And Senator Lowe, along those lines, one of the things that was brought up at the university at the briefing I saw in February was that professors are in a dilemma because it is developed to the point where you can have it write your papers. And if you manage it right, there's no way to know that it wrote the paper. So now they're in this dilemma of having to go back to the old blue books and have you actually write an essay as a part of your final test. Otherwise, they have no way of knowing whether or not you really did the work. Anyway, go ahead, John. Oh, other questions?
Thank you,
Yes,
Chairman.
Senator Conrad.
I'll go after my good
Coin.
friend, Senator Sanders.
Thank you, Senator Brewer, and thank you, Senator Cavanaugh, for bringing this forward. And isn't it all about like the data we've put out there, and now someone's collecting that and using data, and whether it's false or not, right? So is there an industry that has been created, like Meta, right? They collect data, and now they're using the data in whatever form, whether it's right speeches or papers or whatever. Or like Senator Halloran earlier said to his phone, call my office, right? That phone used a little bit of artificial intelligence by finding that number and calling. So we're all using it in some form already, but it's expanded greater to falsely get your education moved forward or business. So who owns the data that they're using?
Well, that's a great question and probably well beyond my ability, but I think you hit on something really, a good distinction there. I think what we're talking about with both of these studies is something what would be called generative AI versus other assisted AI. So like Siri, or like when Senator Halloran says to his phone, call my office, that is a form of AI, but it's not generating something. It's not creating something. But the big leap forward of groups like ChatGPT and others similar to that, and that everybody's racing, is ability to create something from our perspective out of nothing. Just where I just give it a prompt and say, write a speech in the voice of John Cavanaugh about, his favorite movie, and it can write a whole long speech about how much I love Die Hard, right? And I don't have to give it any other input, but it could and I could just say 5-minute speech and it will write that. So I think that is where we're going down that path. But again, my concern is not that the inputs are fake or where they come from. I am concerned about those, don't get me wrong, but that's not what we're addressing. My concern is that the outputs, that I can have it generate something that would say, John Cavanaugh hates Die Hard, and then all of my constituents would get that in a video or a mail of me talking about how I don't like it, and then they would get the wrong impression about my opinions, and that the voters would have no idea that that was fake. And so the technology is getting so good that they can make a realistic video or audio representation of me saying something I never said. Mm-hmm. And I think the question is, how do we address that from a governmental standpoint? Do we just put a disclaimer on it, say require them to post on there, this is generated by AI or something along those lines? And then the question, if we do that, which was the question that was posed in 1203, was whose obligation is it to enforce it? Who has ability to call it out as fake? And who makes a determination if it's fake? All of those things, NADC is not equipped to do that. And as all of us who've been through a campaign know, they're very contentious, and a lot of us do take issue even with things that are half true that are said about us. Mm. And the question is, are we getting into half truths? Are we getting into misrepresentations? Are we getting into mischaracterizations? So I think it's about the output and not the input. But I think there are legitimate concerns about who owns the data and the inputs. And I'm very suspicious of all of those things, but that's not what we're seeking to address here.
Thank you.
Now, Senator Conrad.
Thank you so much. No, I'm glad Senator Sanders had a chance to ask that. And since this is a joint hearing and before everybody gets started, I just wanted to maybe tee up a few areas that I have remaining concerns about, and hopefully some testifiers will take it up, or if you wish to respond, Senator Cavanaugh, that's great too. I'm very skeptical of additional regulation of political speech. I think it runs afoul of the First Amendment, if not legally. I think it has a chilling effect, even speech that we find confusing or confounding or distasteful or misleading, even that. So that's part of the through line for me here. As I was reviewing the federal government's treatment of this issue and some of our sister states' treatment of this issue and this new and emerging issue and landscape, the biggest issues that I saw out there were problems with clear definitions, definitional problems in relation to legislation like this, enforcement problems, which you've already touched upon. And I also am just really struggling too with how this interfaces with a right to anonymous speech or a right to, a more robust political dialogue online. I mean, political satire and impersonation and cherry picking has always been a part of political speech. So there's new technologies that are utilizing these same approaches that have been with us since the dawn of politics. I'm concerned about a reflexive approach amongst government to regulate either through civil systems and or even worse, by creating new or different criminal penalties and what that would subject our citizens to. And I'm not convinced that this is needed, nor that there's a clear way to craft it without running afoul of the First Amendment. So those are just some big picture issues that I was thinking about during our dialogue last session, that I've reviewed in advance of this hearing today. If you'd like to respond, great, or if other testifiers want to take it up, I ask a lot of compound questions, which is a problem. I know, I'm working on it.
We all grow as we go through this, John. No, I appreciate the comments, Senator Conrad, and I share a lot of your concerns as well,
Yeah.
obviously. And I think that's one of the reasons this for the study is a good approach, is that to look at what, if anything, we should be doing. And I do think there is a distinction between satire and things that are passed off as actual representations of what somebody said. And so I think that's why it's an area where I think we need to be thinking about it. I certainly don't want to be reflexive. I think we need to be thoughtful and deliberate and go through and look at all of the options of what is appropriate. And because the likelihood is that this is going to come up, somebody's going to do this and somebody's going to feel aggrieved by it being done. And then we're going to act reflexively at that point. And so I think getting out in front and having the conversation as we go before it actually comes up is probably the smarter thing to do. And again, whether we decide that there's something to be done or not. But as to what sister states are doing, I know we've got folks from the esteemed NCSL here. To maybe they can tell us what other people have done. And to the criminal penalty, I will tell you, 1203 I brought did have a civil accountability and disclosure fine. And it was modeled a little on one of our sister states, which was the state of Michigan, which did have a criminal penalty in theirs. But we did shy away from that because I agree with you on the over penalizing people for speech.
Thank you. Thank you, Chair. Thank you, Senator Cavanaugh.
Yes, go ahead, Jane.
Senator Cavanaugh, I know you had mentioned in your remarks about in LB 1302 or
1203.
1203 that you had mentioned disclaimers. And I know that, a lot of advertising, particularly when we watch TV at night on pharmaceutical medication, they ramble through as quickly as possible a disclaimer on medical impact or side effects, all that stuff at the end. And, we have a lot of disclaimers on political ads already. Saying, this ad was not supported or was supported by a separate organization. I mean, and Senator Conrad brought that up too about regulating, but are the disclaimers considered adequate when it comes to saying, this ad was generated with AI inputs and
well, I don't know. I guess I don't know if we have enough information to say whether that's an adequate disclaimer at this point. I would tell you that I guess my intention when I brought that bill was to have a requirement that there was a disclaimer so that the receiver of the message was on notice, but not to have such an onerous requirement on there that somebody would not be able to engage in speech in the way they chose. They would just have to, if they chose to engage in that form of speech, that they would have to disclose that that's what it was. So that was trying to thread that needle and of those two interests. I think you're right. Probably a lot. These disclaimers are ubiquitous at this point, and almost people are deaf to them. But to a certain extent, that may be the only tool we have. So that's part of the reason for the hearing is to say I might be totally wrong. Maybe we'll hear from NCSL that there's some great system in Alabama that's working gangbusters, and we can do that. But that's one of the reasons for the hearing is because 1203 just wasn't the right answer. And so still looking for the right answer.
Thank you.
All right, additional questions for Senator Cavanaugh? All right, let's stick around for
Yep.
close. That's not a request, that's an order.
That's an order.
Okay. Jim, you're up first.
Good
Welcome to the
afternoon.
Government Committee.
Thank you, Chairman Brewer, members of the Government Committee. Appreciate your time this afternoon. My name is Jim Tim, that does rhyme, Jim-Timm. I serve as President and Executive Director of the Nebraska Broadcasters Association. We represent the state's FCC licensed free over-the-air radio and television stations that are licensed by the Federal Communications Commission to serve their respective communities around the state. As you might expect, when you hear Federal Communications Commission, that means our members are heavily regulated, and that's why this particular topic is of interest to our members. I'm grateful to Senator Cavanaugh for the opportunity to address possible changes to state law regarding how AI might be used in political advertising, and also appreciate keeping concerns about First Amendment involved in this conversation as well. I'm going to take more of a narrow thread than some of what's been discussed so far. And this has to do with the potential for unintended consequences in the way that our members are regulated with political advertising. For our members, it would be critical that whatever legislation comes forward not only ensures responsible AI use to the best of our ability, but also that it protects us from liability when it's not made apparent to a station that AI was used in production of a political campaign ad. As was referenced earlier, several states across the country are in various stages of trying to legislate these concerns. We've witnessed a concerning trend as broadcasters in several states with legislation that's overly broad and fails to accurately define who's liable for AI-generated content in campaign advertising. In some cases, it's been proposed that local TV and radio stations should be solely responsible for detecting AI content in political ads. If you have a fever, you can get your trusty thermometer, take your temperature, and find out pretty quickly whether or not you have a fever. If you tweak your knee and it's bothersome, you can go to your doctor, perhaps get an MRI, and that MRI will show you things that couldn't be seen any other way. There is no such thing as an AI detector machine. There is nothing like that. So our concern is how are broadcasters supposed to determine when a political ad has AI content unless the person who created it and brought it forward to the station for airing says AI was used in the creation of this message. There's no machine, there's no software, there's no super smart whiz kid in the back of the room who can go, oh yeah, that had AI, or no, there's no AI in that. It's impossible for us to know. So we have no magical powers to make those determinations, and we're asking for the help of this body as this discussion moves forward to help protect us, because we are the carriers, as you know, of a lot of messages around the state, and we appreciate how our airwaves are used for that purpose. And because of the demands and everything that comes with monitoring this, we just want to make sure that we can continue to support those who want to use our airwaves without being burdened with testing or proving something that frankly is impossible to test or prove. I would guess at some point AI will create some kind of an AI detection process, but I don't believe that that exists yet.
Mhm.
In our world, it's the advertiser and not the broadcaster who's responsible for the content of their message. The broadcasters are merely fulfilling their contractual obligations when they're airing a political message that's provided to them. We deal with something from the federal government called the No Censorship Rule, federal law that dictates that broadcast stations are prohibited from censoring or rejecting political ads that are paid for and sponsored by legally qualified candidates, and therefore protects stations from liability for airing those messages. We can't touch your messages, their messages. Federal law also requires stations to air ads from federal candidates. We cannot say no to a federal candidate who wishes to purchase airtime. And it states that stations cannot turn away the candidate based solely on the content of their ad. So once again, we have that federal protection, but we're asking for help here at the state level as well. So I've got some language here that has been successfully adopted in some states. I don't have the current list of how many states, but this will be in the handouts that I provided. But we think this language would help us support the concerns that I just put before you. Both the responsibility and liability for ensuring political advertisements comply with all aspects of law, including disclosure requirements regarding content created with artificial intelligence or prohibitions or other restrictions on such content being included in political advertisements, shall rest solely with the advertiser and not with third parties paid to carry such advertisements, such as radio stations, TV stations, and their respective websites. So on behalf of our member stations across the state, we respectfully ask you to keep these considerations as this discussion continues, and would be happy to answer any questions now or in the future as this conversation continues. But thank you for the opportunity to address you this afternoon. Be happy to answer any
All
questions.
right. Thank you for that testimony. Let's see if we don't have some questions for you. Questions for Jim. Ms. Jones. All right.
Okay.
Thank you.
Thank you.
Thank you for written testimony. Okay, next up, Adam. Oh my God, that's horrible coffee. No, I'm serious. I've been on the Russian front and drank coffee out of an ammo can. It's better than that. Oh, yeah. Welcome to the Government Committee.
Well, good afternoon, Mr. Chair Brewer and members of the committee. Thank you for the opportunity to speak here today. I'm Adam Cook, that is ADAMKUCKUK, and I'm a policy associate with the Elections and Redistricting Program at the National Conference of State Legislatures. I'm here with my colleague, Ben Williams, who's the Associate Director of the program, and we are here today to provide an overview of recent legislation on artificial intelligence as it applies to campaigning specifically. So for the members of the committee or the public watching who aren't familiar with NCSL, we are the nation's bipartisan organization supporting the work of both legislators and legislative staff throughout the states and the territories. We believe in the importance of the legislative institution, and we know that when the states are strong, our nation is strong. So NCSL provides a number of services, but our bread and butter is nonpartisan research and analysis. So any requests for information are handled on a confidential basis. So please reach out to any of us at NCSL at any time, to either Ben or I, and we can pass that along any questions you have to our peers who cover any other subjects. So AI has really been the hottest topic over the last 2 years, but something I want to preface with is that AI is only the latest wrinkle in a long line of technological changes that have impacted state campaigns and elections. Candidates, campaign staff, election administrators have always had to deal with new technologies, from political television ads in the mid-20th century to the recent rise of cryptocurrency contributions. So with the 2024 elections quickly approaching, state policymakers have been contemplating how to regulate this technology in a presidential election year. Now, since 2019, at least 19 states have enacted laws regulating AI's use in political messaging. So I say maybe because many states may have other laws, such as libel laws, that they believe will cover AI as well, but we are only really keeping track of the ones that are very explicit in regulating AI in political messaging. So there have been three main considerations in AI political messaging legislation. So there's how bills define AI, what regulatory provisions are included, and then what enforcement provisions look like. We're going to primarily cover these things today, but we will briefly touch on what the federal government has done as well. Much of what we will cover today, Ben and I, can be found in the white paper that my colleague Sanam Hushadari and myself wrote very recently. So when we talk about AI today, we're primarily referring to generative AI. And generative AI is AI that creates images, video, audio, text generation, like from ChatGPT. It's also generative AI, but as of right now, no states have enacted any laws involving text in the campaigning context or election context as of today. Many states define AI to include all three mediums, images, video, and audio, but some may only cover one or two. So Texas passed legislation in 2019, and they defined deepfakes as video. And this notably left out other sorts of media. And this has left the law's applicability to audio and images unclear. Now, we may be talking about generative AI today, but states use a variety of different terms to refer to generative AI, such as synthetic media, deceptive media, deepfake, or a variety of other terms that encompass the deceptive use of media to influence an election. Some states may use several of these terms, whereas others may only use one or two of them. An important thing to note is that in state statutes, there is no one accepted definition of AI. There's really no accepted definition in statutes. There's not really an widely accepted definition even amongst computer scientists. So states have taken a couple of different approaches to defining AI, which we've characterized as either direct or indirect definitions. An example of a direct definition is such as Florida, that defines generative AI as a machine-based system that can, for a given set of human-defined objectives, emulate the structure and characteristics of input data in order to generate derived synthetic content. Quite a mouthful, but some other states have also decided to reference AI technologies, but they don't define them directly. So Idaho and Washington, they both define synthetic media as using generative adversarial network techniques or other digital technology. So generative adversarial networks, which are also sometimes referred to as GANs, are one of several underlying models that AI uses to generate content, with diffusion models being another example of a type of model. Now, because GANs are only one of many models, these definitions may not capture all AI-generated content. So one that's specific to GANs may not end up encompassing diffusion models, for example. Then there are states that don't mention AI at all. So there's California that uses the term materially deceptive media, and they define it as the confluence of two different conditions. One, a reasonable person would believe that the media is authentic, and two, a reasonable person would have a fundamentally different understanding of the media if it were unaltered. Now, this definition makes no mention of technology at all, and thus it may apply to any misleading or false content, whether it was generated by AI or otherwise. Now, one thing to note, though, is that actually just 2 days ago, California's legislature did recently pass new legislation, and it was enacted by the governor that is more specific towards AI. So this is mostly referring to their prior legislation that they passed in 2019. So that's how states have been defining AI, but what are the provisions that states are actually writing in to regulate AI's use in political messaging? So states have taken several legislative approaches to regulate AI. However, no state has adopted a complete ban on deceptive AI-generated political messaging. And this is possibly because of First Amendment concerns. So new state laws have done three different things. They have either established durational prohibitions, they have had disclosure requirements, and then some states have also implemented digital disclosure requirements. Furthermore, Some states have also chosen to just use current law to address deceptive practices. So though there are no full prohibitions that currently exist, 2 states do have what are called durational prohibitions. So these laws make it a crime to publish a deepfake intended to influence an election within a specified time window. So Minnesota prohibits the publication of deepfakes 90 days prior to an election, and Texas prohibits publishing a deepfake video 30 days prior to an election. But by far the most common approach that we've seen to regulation is by requiring disclosures. So, as was spoken about earlier, most state campaign finance laws require disclosures on ads, identifying the committee of the person who funded it. So, it says paid for by Mr. John's committee, for example. So similarly, AI disclosures require content to include text or an audio statement stating that it was generated by AI. Now, disclosures and durational prohibitions can work together. Disclosure requirements often include a durational prohibition, but they still allow the content to be published so long as that disclosure is included. So for example, Arizona prohibits deceptive AI-generated content 90 days prior to an election, unless the message includes a clear and conspicuous disclosure that the content was generated by AI. So Washington, on the other hand, does not include a durational requirement, and thus disclosures must be included on political deepfakes published year-round. Another approach has been to include what are called digitally embedded disclosures. So these are types of disclosures that require information to be contained in a digital's metadata file. And so metadata is the descriptive information about a file's creator, when the file was created, when the file was edited, those sorts of things. So Colorado and Utah, they both require that AI-generated content to contain metadata about the program that was used to create it, who created it, when it was created, and then also in the metadata, they require a disclosure statement saying that it was, in fact, created by AI. These sorts of requirements allow news or social media sites that have these images uploaded to their platforms, or any person who wants to, the ability to independently verify the media's authenticity. Now, AI laws may not be needed in some states, as their current laws may already cover any unwanted conduct. So in early 2024, New Hampshire residents received an AI-generated phone call that sounded like President Joe Biden, telling voters not to vote. So at the time, New Hampshire did not have an AI political messaging law, so the New Hampshire Attorney General's office instead charged the political consultant behind the calls with 13 counts of voter suppression and 13 counts of impersonation of a candidate. But now in August 2024, New Hampshire did enact a bill which requires the disclosure of deceptive AI in political advertising. Then, just to go over fairly quickly here, there are some exceptions to many of these laws. So to avoid First Amendment violations, some states have built in exceptions to satire or parody. New York is an example of this. Another exception is for media providers. So in Wisconsin, liability for damages is waived for broadcasters or online platforms, so long as they didn't create the content. So that is what I have prepared for you today. So I can hand it off to my colleague Ben here in a second, but I'm happy to take any questions you may have right now.
All right. Questions for Adam? Questions. This is handy, your slideshow. Kind of breaks everything down in sequence, so thank you for this. All right, let's bring Ben up then and we'll get kicked off. Ben, I'll have you go through the same process of green sheet introduction, name, spelling, and all that.
Absolutely, Mr. Chairman. Thank you for having me. And hello, members of the committee. My name is Ben Williams, BenWilliams. I am the Associate Director of the Elections and Redistricting Program at the National Conference of State Legislatures. I work with my colleague, Adam Cook, and I will say he gave the first part of this testimony because he's the brains behind the technical part of how AI works. But I am the attorney on staff, so I will walk through the remedies section and the legal considerations that states have built into their laws addressing AI. So most of the legislation includes some form of civil or criminal penalty. That is the most common remedy, but these have not been widely tested in courts. As you can see in the slideshow that was provided to all of you, a lot of these laws were just passed within the past 12 to 18 months, and many of them have not been used in a political campaign season yet. And so I'm expecting that by next year, we might have more information on how these laws have stood up constitutionally. But for now, we're still in an early stages of analyzing how effective these laws are. Most states have chosen to leave enforcement to civil courts. Candidates in most states can seek injunctive relief to prohibit the further publication of an AI-generated image of themselves. Mississippi, for example, has extended a cause of action that candidates can use for wrongful dissemination of digitizations to other individuals who may have been falsely depicted. And that could include lay people, but it could also include public officials. Additionally, several states allow candidates who are running and are the victims of these deepfakes to seek repayment of court costs for damages related with enforcement. If they are the subject of a frivolous lawsuit or prevail in court on the merits. Due to the increasing sophistication of AI content, people may bring lawsuits against real content, claiming it is fake. If you talk to the Department of Homeland Security, they will tell you about examples of this happening in foreign elections in Turkey and Argentina, for example. Alabama has attempted to remedy this by allowing the defendant to obtain court costs and attorney's fees for frivolous lawsuits. In addition, several states impose civil fines. So New Mexico and Utah, for example, fine offenders $1,000 for each violation for disseminating materially deceptive media and synthetic media, respectively. Colorado's civil penalty may include imposing a penalty of 10% of the dollar amount used to promote the deepfake, which is really getting at the social media context where people can pay money to Meta or to X to promote certain posts. About a third of the states have also enacted laws that have criminal penalties specific to their AI political messaging. Although more uncommon than other penalties, some states have punishments of prison time. For example, Texas's law, which my colleague Adam alluded to, was the very first law enacted in the country, allows a maximum sentence of 1 year in prison for a violation. Some prison sentences are tied to specific conditions, such as Minnesota, where it's a 2-strike rule, where the penalty for prison occurs on the second violation. In Mississippi, violations intended to cause violence can be given a maximum of 5 years, whereas a violation without violence has a penalty maximum of 1 year. Some states also have criminal fines that can be imposed of instead of prison time. It can be up to the discretion of the judge, or it may be a mandatory sentence. Michigan has a fine of $500 for the first violation. That's among the nation's lowest. Minnesota's fine of $10,000 for the second violation is the nation's highest. Pivoting over to Congress, there haven't been any bills that have been proposed that have gotten anywhere in Congress. There are a couple of bills that have introduced that mirror what states are already doing on disclosure and prohibitions. And there have been some bills that would require a federal agency to monitor AI use within it and to monitor it in the electoral process. But again, this is very early and preliminary. Adam already alluded to the FCC on AI robocalls. Those are illegal under the Telephone Consumer Protection Act, according to FEC rule. And the FEC is currently looking into regulating AI-generated political ads, but has not released any opinions as of yesterday when we wrote this memo. With that, I'm happy to take any questions that you have. If you have a technical question, I'm going to bring Adam back, but I'm happy to answer any of the remedial questions now. Thank you for the time.
All right, thank you. All right, questions? I think we're a little overwhelmed by your slideshow here.
Well, if you have any questions in the future, just note that you can always email. And this is open to members of the public too. We field questions from public citizens quite often. Oh, sorry.
Yeah.
Senator Rabel.
Oh, thank you so much for coming. I have a question. So you mentioned all the implementation of some of the civil penalties, but to the best of your knowledge, has anyone ever been, I guess, found in violation of this, and have they been fined? And if so, are there some examples out there?
Yes, Senator Rabel. I'm going to look. I don't think so. I haven't heard of anything. I know that the Minnesota law that was referenced in our testimony was challenged facially in court, which means that it wasn't as applied to a specific person, but someone just brought a challenge saying the law inherently violated the First Amendment. That was dismissed by the court in Minnesota. But again, a facial challenge is not the same as an as-applied challenge. Who knows once someone actually is fined or prosecuted under one of these laws, what would happen? But as you can see from the chart, we're really early in the early stages here.
All right, additional questions? Okay, just making sure. All right, thank you for your testimony.
Thank you, Mr. Chair.
All right, next is Spike. Spike, come on up. Spike, this will be the last time I get to see you in that chair. Or you just get to see me in this chair, so.
Is this our last
Good
hearing?
that you're
He
the,
said that last
it's good
I
that
feel
you're.
like he says that every time.
No, it is legitimately this time. That was hearings. Hearings, this is not an interim
It was a
study.
deep fake Brewer.
It's the
All right.
longest goodbye,
We're
but
gonna
it
have
has
this
been an
3D
honor to
image.
testify in front of you in this committee. I'll say that. Good afternoon. My name is Spike Eicholt, S-P-I-K-E, E-I-C-K-H-O-L-T. I'm appearing on behalf of the ACLU of Nebraska to testify on both of these interim study hearings. You're getting a copy of my testimony, so I won't read it. I'll try to summarize it and be responsive to some of the things that you've heard already. I'm not an expert in this AI stuff, whether it's generative or assistive or whatever you want to call it. But the studies both look at essentially this situation, this phenomenon of AI, and really essentially what the legislature should do about it. And a couple of things I want to put maybe before the committee for you to think about for those of you who are coming back next year. You're being asked to consider legislation dealing with expressive speech in elections and campaigns. That's significant because you are dealing with core First Amendment protected speech. Even the representatives from NCSL, when they talked about what other states have done, were clear to caution you that a lot of things have not been tested in courts. They may not be constitutional, they may be suspect, who knows. A couple of things, and I've got a case that I've referenced in my testimony. Our U.S. Supreme Court has says that sort of the novelty, if you will, of the new technology doesn't diminish the protection that the First Amendment provides for the speech. So if I have a First Amendment right to write a letter to the editor that says, don't vote for this candidate, that person is not a good candidate, they're not honest in my opinion, that's First Amendment speech. I can't be cited for that. I can't be charged. Well, I could be, but no court will enforce that prosecution or civil suit against me. That's no different than if I create a manufactured person to say those same things. One thing that I think that people are talking about, and they conflate the issue of AI with this notion of it's deception. I think that's really what Senator Cavanaugh and perhaps Senator Brewer are looking at, is to look at the issue of deception to the voters. And in other words, you can have people use AI for their own campaign. For instance, if you got a small campaign office, you've got a ChatGPT account, you could somehow have a standard email response go out to every constituent that contacted you, and you could pre-program it, whether it's to ask about property tax reform, sales tax reform, something like that, where you can give a meaningful response to your voters. That's not deception. You're using the technology to interact with voters and potential voters. And that's really no difference in form. Well, maybe it's a difference in form than having standard letters that you have in your office already. When somebody from your district asks you about Second Amendment issues, asks you about special session, asks you about voting rights, you've got a prepared response. And so the technology is not necessarily insidious. It's not necessarily harmful. We shouldn't always just fear everything because it's new. So I think really what the desire is try to do something to address the situations in which people use AI to generate something that's going to give a false impression to the voters, or going to be deceptive, or is going to impersonate somebody. We already have crimes for that. On the last page of my testimony, I list a series of crimes that we already have that focus on that. For instance, we have a general crime of criminal impersonation. It's a class 4 felony. And our Supreme Court has even upheld that prosecution where if I'm stopped by a police officer and I give a different name of another person, that's a felony in and of itself. More than just false reporting, it's considered criminal impersonation. If I create a program, an image, a little video pretending to be somebody else, I'm impersonating that person. I would submit you can be prosecuted now for that. And the means, it doesn't really matter. What it's done is the act that you do and the deceptive act, the deception that it causes. That's the crime. That's what I think you want to regulate. And I think that's what you want to focus on, because our court, or the U.S. Supreme Court, has been clear that the First Amendment does not protect you from making false statements. It does not protect you for criminal deceptive practices. But it certainly protects you to express political opinions about candidates and people in government. And another thing, as I was sitting here thinking, I can see situations where somebody can use a generative AI program in support of a candidate. So for instance, say I support Second Amendment rights, and I know my candidate does support Second Amendment rights, but I'd like to have a video of them actually doing something with guns. But the videos that I find and the stock photos that they have on their website are just not good enough. I want to have something that looks good, good lighting, has them look sort of dashing and daring, and a real meaningful defense of the Second Amendment. And so I create something in support of a candidate. I don't know that that's deceptive. It might be deceptive, but it's not to cause harm. And I think if we don't want to regulate this stuff, we don't want to prohibit that kind of thing, because I think that is protected by the First Amendment. I know I've just kind of rambled, so I'll answer any questions if anyone has any, but I did include some statutes that you could look at. If you're going to look at regulating something in the criminal side, I would submit first, I think the current criminal statutes that we have now are adequate. And if they're not, amend those. Senator Bosar had a bill last year on this issue that would have created a whole series of new crimes, and our association opposed it just for that reason. Particularly when you're talking about First Amendment things, you shouldn't just jump over the cliff. You're going to wait. You got states that have already passed these things. They're already being challenged in court. One thing we should do is defer and see what happens with those. But I'll answer any questions if anyone has any. Sorry.
Despite you have good rambling, so I didn't mind it at all.
Well, thank you.
Yeah, so that's the trick is if you're going to try and do something to limit it, don't do it in a way that you cause all these other crimes that are unintended and then just gum up the system with more crimes. All right, questions for Spike?
I can just say one thing I thought of.
Yes,
Some
go
people talked about maybe an advisement or a notice that this ad was created with AI or something like that. I think you should have some kind of confidence in the public, because when people tell you about, oh, did you see that video of that celebrity doing X? People already can recognize AI now. Now, maybe it'll get to the point where you can't do it, but people appreciate satire. They appreciate parody. They get that. The problem, I think, with having candidates and people in office have to give advisements, one, that probably is First Amendment problematic, but two, we don't require in other settings. For instance, people use Photoshop for their campaign literature all the time, and there's no advisement. People use filters for their sort of social media accounts and their pictures and so on to sort of enhance their image, and there's no requirement that be done and advise the voters. I think people kind of understand, that, wow, the candidate knocked on my door looks a little bit different than their glossy photo for the pamphlet they handed me. I think people get that. And I don't know that it's really any different really with the AI setting. So that's just one thing I wanted to put on the record.
Yeah, well, for those that have been here 8 years, we've been told that our pictures don't look right for a reason, I guess. All right, anything else for Spike before we turn him loose? All right, thank you for your testimony.
I have a question.
Oh, Senator Conrad.
Thank you so much. And thank you for bringing forward this testimony, and I think an inventory of at least partial or perhaps comprehensive, I'm not sure, of existing criminal penalties and that exist in Nebraska to address these matters is really helpful. And one thing maybe Spike, or maybe other testifiers know, I think from my understanding, the real concern that proponents of reform legislation are seeking to address is that widespread voter confusion or voter suppression. So we're all well familiar with this recent example out of, what was it, New Hampshire or Vermont or whatever, and somebody used AI to imitate President Biden's voice and said, don't vote. Well, number one, I think voters are smart and will not take President Biden's advice as to whether or not they cast their vote, whether it's AI generated or in person. But there's also a host of federal laws that exist in regards to spreading misinformation around elections. Like you can't, send out like widespread postcards that say, hey, go vote on November 15th. That's election day. That's actually not election day, right? There's like a host of state level crimes and federal crimes that ensure accuracy and messaging around the components of voting itself. Do you have any sense about how that works with the federal interplay, or is there a resource there that we should consult prior to moving forward with anything next session, if we do move forward with something next session?
Thank you. I know that the FEC is considering some sort of regulation regarding AI technology to sort of update the current federal laws regarding some of the examples that you have now, as far as false and misleading advertisements or campaign messaging. I don't think the FEC has adopted anything regarding that, and I don't think Congress has really passed anything in this sphere that's very clear either. The NCSL people might know. I mean, the states are just kind of doing it state by state right now.
Yeah.
But ultimately, I think the concern that we have, or that people have by AI, is addressing the kind of persistent issue out there, and that is the temptation for people and interests and candidates to use deception to gain an advantage, to deceive the voters somehow. And robocalls are not new.
Yeah.
I mean, people can impersonate candidates' voices just old-fashioned style. That's not new. That's a problem that has happened. It's happened in states, and within the states, happened across the country. So I don't know if that was responsive to your question, but I know that.
Not really, but it's also
Okay, thank
helpful.
Thank you.
Thanks.
All right, any other questions? All right, thank you for your testimony. All right, Senator Cavanaugh, welcome back to the Government Committee.
Thank you, Chairman Brewer and members of the Government, Veterans, and Military Affairs Committee, Military and Veterans Affairs. Well, I just wanted to start my closing by, I took the liberty of asking ChatGPT to describe Senator Brewer's speaking style. I didn't do it for everybody.
Go ahead, transcribe it.
But in light of the fact this is last hearing, I thought I would take this liberty. Nebraska State Senator Tom Brewer's speaking style is passionate, direct, and often forceful. He speaks with conviction, particularly on issues related to veterans affairs, Second Amendment rights, and rural Nebraska concerns. Brewer is known for his no-nonsense approach and military background, which often comes through in his speeches, and a sense of urgency and decisiveness. He tends to be straightforward in presenting his arguments, often using personal anecdotes from his life, including his military service, to make his points. His tone can be confrontational when he feels strongly about a topic, but it also reflects his dedication to causes he champions. So I think you can all make your own determination about how accurate that is. In my personal experience, I do think that's an accurate description of Senator Brewer. But the only question I posted was, describe the speaking style of Nebraska State Senator Tom Brewer. So there's all that kind of information that it was able to glean from Senator Brewer's previous statements. That's not what we're here to talk about. That was just for fun. But I appreciate the testifiers. I really do. I would say the thing I learned here today is that there are 29 states that have done something about this. Or I'm sorry, 29 or 19? 19 states that have done something about this. And I'm sure there are more than 19 different versions of how they've addressed it. And I think that Senator Conrad and Mr. Eicholt made some good points about not rushing into doing something, because all of those different states have taken widely ranging different approaches. I do think that we don't want to end up in a situation where we haven't given this any thought before we are presented with some kind of big event. The New Hampshire event was a big event, and the New Hampshire then passed legislation in response to that. Was it the best legislation? We don't know yet. Is it constitutional, legal, appropriate, thoughtful? Maybe not, because they did it in response to something that was so jarring. And so that's why I think it's really important we have this conversation now. I did learn a lot from the folks here. I appreciate Mr. Tim's testimony of things we need to be concerned about when we do pass any legislation. And I just wanted to flag some of the things that I would certainly think we would want to include, which are specific exceptions for broadcasters and for satire and parody. But as Mr. Eichholt pointed out, maybe some of our laws already address what we may need to get at here. And that we might not need to do something. And, I think that's a valid response to any question, is no action might be needed. But we don't know that unless we actually think it through. So I think we've got some great stuff to work with from the presentations here. I think we've got some food for thought, and I'm very happy with all of our opportunity to learn here. And I intend to be back for the next 4 years. And so I'm happy to work with the members here who intend to join me in those next 4 or 2 years to work on this issue. And I guess I would be happy to take any other questions.
All right. So, thank you. Let's see if we have questions for Senator Cavanaugh. Well, let me read in the letters. We had 9 proponents, 3 opponents, and 0 in the neutral. And with that, I will close my final event as the chair of the government committee. I promise.
Final.